Call the third case on this morning's docket, case number 117788, State of Kansas v. Cameron Lee Johnson.
Mr. Chief Justice, and may it please the Court, Kai Mann of the Appellate Defender's Office, on behalf of the appellant, Cameron Johnson. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. On October 31st, 2016, Mr. Johnson pled no contest to felony murder, aggravated kidnapping, aggravated assault, and criminal possession of a firearm. The factual basis as stated by the state alleged that Dorian Allen and Angela Lease were on a date when they came into contact with Mr. Johnson and two individuals. All 5 people got into a vehicle, and when they arrived at an apartment complex, handguns were pulled on Mr. Allen and Ms. Lease, and Mr. Allen then fled, and Ms. Lease was transported to a vacant lot or field where she was shot numerous times, resulting in her death. The state noted during the presentation of facts that Mr. Johnson had discussed the details of these events with police, and that the district court had listened to his statements at a preliminary hearing for one of his co-defendants, but did not offer the statements into evidence. Sentencing occurred on December 6, 2016. Mr. Johnson, citing his cooperation with authorities, requested that he be sentenced to the low number in the grid boxes for his grid sentences, running concurrently to the anticipated hard 25 for the felony murder. The state requested the middle number in the box for the grid counts, but also recommended they run concurrently to the felony murder. The district court denied these requests and sentenced Mr. Johnson to a hard 25 for the felony murder to be followed by a life term of post-release supervision. That sentence was run consecutively to a 272-month sentence for the aggravated kidnapping. In ordering that sentence, the district court stated, "This was a crime of extreme violence that the victim was subject to. I heard your statement that you gave the police at the preliminary hearing. It is clear to the court that the final moments of this young lady's life were very cold and you showed her no mercy. As a consequence, the court can show no mercy to you." The sentence of 8 months for felon possession of a firearm was also run consecutive to the murder and kidnapping, but all those sentences were run consecutively to a 12-month sentence for the aggravated assault.
The criminal possession is actually ambiguous, isn't it? It talks about it running consecutively to the other grid crimes, or concurrently with them, and then I think there's two different. He speaks out of both sides of his mouth on the criminal possession. He
kind of does. There's ambiguity. I initially, when I briefed this, I read it the first time and believed that he ran those concurrently. However, in preparing for argument, when I took another look,
contradicts himself.
Yeah, I think he may have contradicted himself and ran consecutively, and it's also kind of further subject to a little bit more ambiguity. And I know the journal entry doesn't control, but the nunc-pro-tunc journal entry changed those to also run concurrently. And so again, it is kind of unclear.
Does that affect only the criminal possession, or does it affect other counts?
I believe it only affects the criminal possession of firearm.
So what do we do about that?
Or
can we do anything about it at this point?
I believe, that if this court finds it is ambiguous, I guess for the first time at any time, that would be ambiguous with the nature and time that is meant to be served, and therefore in legal sense this court could remand it back. Also, I believe that there are 2 other issues that need to be remanded back to the district.
I understand. Yes. There are only 2 other live issues right now, right? Because the state's conceded the lifetime post-release.
That was my understanding.
Okay.
The state may say something differently, but that's what I understood.
Okay, thank you.
And regarding the restitution at the district court stated the restitution will be ordered and later noted that it was not waived, but the district court didn't hold open a continuance and issued 2 journal entries saying that restitution was to be determined. This court issued show cause to the parties to ask why that jurisdiction, or why the case should not be dismissed for lack of jurisdiction regarding the restitution after the parties responded. This court retained jurisdiction, which brings us to argument today. And the first issue I would like to start, if the court is okay with this, I would like to start with the abuse of discretion argument regarding the kidnapping count and the felony murder.
Is the abuse of discretion stem from using evidence that was produced, and I assume this judge presided over the preliminary hearing of the co-defendant?
Yes.
And in that preliminary hearing, just trying to set this up, a statement from Mr. Johnson was provided in providing probable cause on the co-defendant.
That's what this record...
And what prevents, so it's your position that any evidence or the statement made by your client in that preliminary hearing cannot be used in a future sentencing with Mr. Johnson?
Almost.
Okay, tell me what the problem is.
I think that if that statement is to be used, it needs to be entered as evidence in this case. I think the problem is that we have a collateral proceeding. There's no evidence in this record of what that statement is. And so therefore, I think to be able to be used to sentence Mr. Johnson, as opposed to simply setting up for probable cause for his co-defendant, I believe that that statement needs to be entered into this case and made a part of this case.
Your complaint is that he's not that he's relied on it, but we just don't know what that was.
Well, I think...
I mean, you're not saying that he couldn't rely on a co-defendant statement if it was made part of the record. Is that correct?
Correct. Exactly, because then it becomes evidence, and then that decision would be based on substantial competent evidence. But here, since it was never entered into evidence, this would be the akin of the district court hearing a news report about the murder and coming in and saying, hey, I heard these...
It's more akin to taking judicial notice of the court's own files and records, right? Because there would be a transcript of the preliminary hearing of the co-defendants. So basically, that's what the judge was doing, taking judicial notice of the other hearing that the judge had presided over, right?
I think it could be viewed that way, but I think it still comes back down to the idea that this was never entered in this case. And, you know, at the beginning of the plea hearing, the district court did note that before getting into the plea that they were here to do a Jackson Ditto. I think this goes into other problems. When that statement was admitted in the co-defendant's case, you know, it goes to probable cause of the co-defendant. However, we've had no litigation as to whether or not the statement is coerced because, again, that's not necessarily...
Why isn't it even more direct than a taking judicial notice? The judge said, I heard. Is it correct that means, you know, he was there, he heard it?
And again, I understand where that's coming from as a matter of mere practicality. You know, I think that is a way to go. But I still believe that if a judge is going to rely on something to essentially double my client's sentence, there has to be substantial competent evidence. And in this case, there simply is no evidence.
But
Well, he relies on just the statement of the state, and that's not, strictly speaking, evidence when the state makes its factual showing that the plea can be entered. That's strictly speaking, that's not evidence, is it?
True, it is not evidence, but at the same time, Mr. Johnson pled no contest and is not contesting the facts as relayed by the state.
Crime.
But I think there has to be some factual basis from which the court can get to, and I think that at least at the plea hearing, Mr. Johnson would have had a chance to object to any facts that were heard or to interject and make any changes. Whereas here, if the district court is relying on a statement that was made and entered in a collateral proceeding, Mr. Johnson has no ability to come in and refute the statement.
Why couldn't he have objected at that point when the court says, I heard your statement?
I mean, he could have objected. You could have raised this objection below.
Or asked for the statement to be entered into the record, or anything to have preserved it for appellate review.
I think that is possible and it would have been helpful, but I still think that this is still preserved for appellate review due to 216820 because we have an off-grid sentence running to an indeterminate sentence, and I think that the abuse of discretion can be challenged on the first time on appeal as to those sentences. And one of the three prongs of an abuse of discretion is the error based on an error based on fact, which substantial competent evidence doesn't support. And it should be noted that to this date, this statement has still never been presented. It's still never been.
Why isn't the judge's the two words "I heard"? Why isn't that substantial competent evidence right there? The judge says, I heard it. I mean, it's not evidence in the traditional sense we think of evidence.
Right. I mean, it still hasn't been subject in this case.
Mr. Mann,
Yes.
in light of that, your complaint is about the mechanism more than a judge clearly could do what this judge did.
Yes.
Your concern is that there's nothing here to be reviewed. It never did get transported over. Is that basically
Correct.
Okay.
Correct.
Okay, so that's what, my next question was going to be, if this had been in Mr. Johnson's preliminary hearing that the judge presided over, and heard Mr. Johnson's confession or statement, whatever it is, but wasn't utilized in the plea or mentioned in the sentencing, the judge could still look at or review what he knows to be the evidence in the entire case. That would have been okay?
I think it would be a much stronger point for the state if that would be okay, because again, this was admitted into the state. It was subject to the adversarial process within this case, as opposed to a collateral proceeding Mr. Johnson was involved in, not as a litigant or a party, but rather as a witness.
Okay, so it's not so much the use, it's how, it's what, at what stage that the judge became aware of the statement as opposed to its use. I mean, it could have been used even in spite of the fact it was never used as in the plea for the factual basis, or not used in the sentence.
Correct. I mean, basically, it boils down to that my argument is that Mr. Johnson should be sentenced based on the evidence in Mr. Johnson's case.
What is the minimum that would satisfy you here then?
I think had the state proffered the statement at either the plea hearing or the sentencing, or admitted a copy of it into the evidence, as opposed to just making a brief oblique reference to it at the plea hearing, but actually presented the statement to the court and made part of this record.
And so, because you don't believe what the judge said was evidence, that did not kick in an obligation under 6404 to object to that?
I think I still think we can still get there under the fact that we have jurisdiction to review grid sentences running to indeterminate sentences viewed or based on an abuse of discretion, and the abuse of discretion here is really a lack of evidence. I don't. I will admit that a 404 objection would have been very helpful, but I'm not sure if it's completely, absolutely necessary in this case, as again, there was no evidence that was entered into this case.
It's akin to a sufficiency on guilt,
Yes.
sufficiency claim on guilt,
Yes.
which doesn't require an objection.
Right.
What about the fact that the state's proffer of evidence, or its factual basis for the plea, what about his statement? And I know we don't have it in front of us, but do you know, was there anything else in it other than what was said? I mean, the judge says, I'm giving you consecutive sentences because you were so cold-hearted at the end of this woman's life. Doesn't the state's factual basis support that without whatever happened in the co-defendant's preliminary hearing?
I think it could, but I also think it's difficult to separate the extent to which the district court was clearly relying on that statement, as he stated when he was sentencing him, as opposed to just...
Can any error in mentioning that preliminary hearing testimony in the co-defendant's case be harmless?
Perhaps, but again, I still think it's difficult to say it's harmless when the district court here explicitly stated it was relying on that statement, which was not in evidence. Again, but not disputing the fact that the district court did have discretion to run these sentences consecutively. It's just the route by which the district court took to get there was an abuse of discretion based on an error fact.
But wouldn't you agree that the things that are said by the state in supporting the plea, the factual statement, taking, they've got all these handguns and they're taking her out on the drive and they go to the vacant lot, and all the things that are said there support the district court's conclusion that the killing, that this young lady's life was taken in a very cold manner with no mercy, and I mean, it's all right there in what the state said without having to talk about that statement. So my point is, I think there's clearly enough in what the state said to have come to exactly the same conclusion. So where's the harm in a reference to the statement?
Because again, if the judge was relying on the factual statement as presented as the plea, he could have said that and could have explicitly made those statements. However, he explicitly stated he was also relying on something that was not part of the plea, not part of the statement of facts.
Isn't this a form over substance argument?
You know, perhaps, but also I think that when we are dealing with life sentences and sentences being doubled basically into a hard 47 or hard 48, I think that the form is extremely important. And if it is form over substance in this case, I think that the law still needs to be clear that the evidence has to be within the case, just as a matter of justice and just as a matter of precedent moving forward to make sure that everybody gets fair sentencing.
One other point, kind of moving off of that, your position is not, or I think the law supports the fact that there has to be a benefit for the bargain, does there? In the sense, I mean, this gentleman received the maximum sentence, whether he had gone to trial and been convicted of it, depending on what the sentence is, but that's another issue. Does there, with the plea going in, cooperating with the state agreeing, is there any abuse of discretion there that the judge? Go ahead.
Yeah, I think so, but not under the factual basis. I think that was just an unreasonable decision on the judge's part.
I understand
Yeah.
that. I'm just.
But yes, I believe there was also abuse of discretion there. I don't believe that a
So
reasonable...
your position is there has to be a benefit for the bargain, or the judge has abused his discretion?
No, I think that in this particular case, citing Mr. Johnson's cooperation and citing Mr. Johnson saving the state having to go through another trial, I think the district court abused its discretion in making an unreasonable decision to deny Mr. Johnson any benefit of his plea. I mean, I think that if defendants were entitled to benefits of their plea, then judges would have to follow the plea agreement because that's where those benefits are usually taken care of. But obviously that's not the case in this state. And so, you know, as far as whether or not a plea is an abuse of discretion or a sentence is abuse of discretion because it denies the benefit of the plea, I don't necessarily think on its own is an abuse of discretion. But I think in this case, it is an abuse of discretion, citing his cooperation and citing his statement, saving the state.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. Regarding the confusion about the criminal possession count running, I don't know that I read the district court's order as being confusing. Basically, the district court's order is felony murder, ag kidnapping, criminal possession, and then ag assault runs concurrently to all of those. But the criminal possession and the ag assault are concurrent at the same time. I think he just did it in the order it was charged rather than reordering them. As to the abuse of discretion, the confession or interview, whichever you want to call it, was specifically referenced during the plea agreement or the factual basis of the plea agreement. In fact, it was the basis for the felony, the predicate felony, relied on for the criminal possession of a firearm. So while it wasn't admitted into evidence, it was specifically referenced by the state, which could have been a time to object if you didn't want that to be used by the district court.
I'm not sure I understand what you just said, because I'm looking at what the state said at the plea hearing, and there's a sentence in there that says, and I know the court has listened to his confession during a prelim for a co-defendant. So there was reference to
Yes.
the confession, and I thought you said there wasn't.
Oh, no, I just said there was. I'm sorry.
Oh, I'm sorry. Okay, I'm sure I misunderstood.
There was, and I think also that confession was what they used to rely on for the underlying felony for the criminal possession charge.
I'm sorry.
Okay.
Can I ask a factual clarification?
Sure.
What happened? Was the judge there, or was the judge listening to a recording?
I don't know that I know, but since he said I heard, I assume
Well,
he
on one
presided
hand, he
over-
said I heard,
Right.
and then what Justice Biles just read used the word the judge listened to. Listening to, I mean, and I'm not sure it matters, but
Right.
I think it might matter.
That's the prosecutor speaking, and I think what the prosecutor's just saying is you heard that when it was played during the defendant's prelim, when you were the presiding judge. That's how I took that statement. But since
Okay.
we don't have the co-defendants,
We just don't know.
right.
And when you said they relied on the confession to supply the underlying felony for the criminal possession, you're talking about him mentioning that he had some previous crime?
Yeah, in order to be convicted of criminal possession, you have to have a
Felony in
underlying
the
felony, and
past.
they just
So
said he confessed to several that would have counted.
But
Essentially.
not in this instance, they were previous? I'm just saying felonies in the past. He confessed to some other felony in the past that would have supported criminal possession in the series of events that underlay these charges,
Yes.
right? Okay, great, just making sure.
What if a judge says to a hypothetical defendant, John Doe, we've known each other a long time. You're a frequent flyer. I know what's in your heart from all of my experience with you, and that's why I'm going to impose X, Y, Z. Can a judge do that?
I think they regularly do.
I think that probably happens too, at least in some measure. Is that permissible?
I don't know.
Can a
if-
judge use his or her sort of personal knowledge as a consideration when imposing a sentence?
Well, usually that personal knowledge is also bolstered by or supported by the criminal history of the defendant. So I think typically they're one and the same. This is the criminal history, and the judge happens to be familiar with that criminal history because he acquired all of that
But
criminal
you
history.
see what I'm asking, sort
Right.
of. Is the sentence must be based on the evidence? Is it a bright line or is it a fuzzy line?
It seems to be a fuzzy line. The rules of evidence are not applicable at sentencing. I don't know of any cases that really have litigated this exact issue, or especially Your Honor's hypothetical, whether it's improper for the judge to rely on his own or her own personal knowledge of the defendant. But I think as long as it's supported by evidence, the judge is allowed to do so. And in most cases, with your hypothetical, it would be supported by the actual criminal history. I think it's relatively common also in co-defendants cases that you look at co-defendants. In fact, oftentimes the defendant wants them to look at the co-defendants because they're saying, hey, the co-defendant got this sentence, so I should get this. So do they have to put on evidence too, or can't the court just take judicial notice of its own files, which is more or less what happened here? And again, also the state used that fact during the plea. I think all of this would have been much cleaner and easier resolved if Justice Nuss's suggestion was followed and there was an objection. You don't want this used, object. And then we can do something to fix it. Regardless, I do think that no matter how this court comes down on this particular issue, no abuse of discretion should be found here because what the actual factual basis was supported the decision of the district court in this case.
Do you have a concern, and this is, well, let me just explain what I'm thinking about. Do you have a concern about the defendants kind of induced to enter a plea based upon a bargain on a sentence? Typically, the prosecutor has the role of looking at the evidence, the strength of the evidence, meeting with the victim, going through the cost of trial, the emotional cost, the burden that is placed on everybody with the trial. And in exchange for that, there's some negotiation. Victim typically approves of these kinds of things. And so the judge is presented with this and really doesn't know much about the case other than what they heard. The prosecutor has done all the legwork on their end. The defendant has done all the legwork on their end, and suddenly the plea is not followed. And what inducement does that create in the future for anyone to enter into a plea bargain on a case?
It's the same we've had in this state for
Oh, I
since plea
understand,
bargaining.
and I would not want to tie a judge's hands. I've sat in that position to always follow a plea agreement, but this seems pretty drastic here. It doubled his sentence on what occurred here, and there was an agreement made with all the parties involved. This was the agreed upon resolution. Any concern about that?
The only way I would be able to address that concern is to say that the judge has to file a plea agreement, and because the judge does not have to file a plea agreement, I don't have the
It just
concern.
almost seems that there ought to be some exceptional, I don't know, but just.
And I just don't know how to get there. But here he was originally charged with the hard 50. The judge could have done the hard 50 and run everything consecutive based on the same. So he's still
Not
got
without
a
a jury, but
benefit.
no, I guess not.
Well, it depends on when
Yeah, I
this
guess
crime was
I don't know what
committed.
time I have. You're right.
Yeah.
Yeah, I just throwing that out. It's concerning to me when all of that happens, and then all of a sudden that this person doesn't receive, while the state receives the benefit of not having the trial and the victim and everyone else.
Let me follow up on my colleagues. Would that then be good cause for withdrawing your plea?
Well, right. Post-sentencing, he would have to prove manifest injustice. I don't think the district court's failure to follow a plea, which they're explicitly told typically at sentencing, during the plea hearing when they accept the plea, that the district court is not bound by the agreement of the state. I don't think that would ever be good cause or manifest injustice to withdraw the plea.
Could you address an issue that I think Justice Biles was heading toward if he didn't label it as such? Assuming, for sake of argument, that it was error for the district judge to have said what he did and therefore in some way relied upon the information provided by Mr. Johnson, can you tell us why that would be harmless? Or I'm sure you're not going to say it's reversible.
I will not say it's reversible. I think it's harmless because the factual basis itself supported the district court's conclusion here. 10 shots were fired into this woman who was taken against her will. I think that's a reasonable judge would have run these counts consecutive, even in light of the plea agreement.
And the fact that the court started with, based on the information provided by Mr. Johnson, instead of any information provided by the state, does that make any difference in terms of the importance that the judge placed on this?
It depends on how this court wants to rule. If this court says that they're not comfortable knowing that the judge would have imposed the sentence otherwise, then I think I lose the harmless error analysis.
Is there a harmless error analysis? I mean, if a judge abuses his or her discretion in a sentencing, do we go forward and ask whether or not, but for the abuse of discretion, the outcome would be the same? Isn't that just reversible?
I don't think just because there is an error in sentencing that
No, it's not an error, it's an abuse of discretion.
Well, but I think the error would be, you first find the error and then you figure out if it's harmless. If the error is he used evidence that he wasn't supposed to,
it's not an
then it's
error.
harmless.
It's a judicial abuse of discretion.
Well, but I'm trying to put it in other cases. So sometimes they make a mistake of law, but the same result still would have happened. You can still do a harmless error analysis.
Do we have case law in which we find abuse of discretion but harmless?
I cannot
Maybe we do.
immediately think
I
of
don't
one,
know,
but I
but-
think there is one recently that you did
Okay.
do that. In 6261 and 622105, you're supposed to do harmless error, I believe, in anything, regardless of whether it's abuse of discretion, if you can get to the harmless error inquiry. You may say here that you can't get to the harmless inquiry if the judge wasn't able to use that because you can't separate it out. I don't think you should, but that could be your analysis, and then you say you can't figure out if it's harmless, so it has to go back down for a remand. And if it does go back down for a remand for any reason, the state would respectfully request that the court again have the opportunity to impose restitution.
And why does jurisdiction still exist in the district court under our case law for restitution amount to be set at this stage of the game? Haven't we said in previous cases that at some point jurisdiction runs out of steam if the district court never acts on its promise to order it?
Well, right, but you've never considered what happens if there's a remand. Why the court then again has jurisdiction to sentence the defendant. Why not permit restitution at that point?
I want to follow up on Justice Stiglitz. Is this an abuse of discretion issue, or is this, is there something else there? I mean, we have vindictiveness by a judge in sentencing. We have abuse of discretion, but the argument here is that he relied on facts that were not part of the record. Is that an abuse of discretion?
I think it sounds more like an evidentiary issue. It sounds like what Justice Ness was saying, it's a 6404, that the judge shouldn't have used evidence, and in which case the harmless error analysis clearly would apply. But they brought it as an abuse of discretion to try and say the judge made an error, I believe, of law in using evidence that wasn't in front of it. him.
So maybe the applicability of harmlessness might depend on what kind of abuse of discretion.
Right. Some, I agree, some errors, probably you're not going to get to an abuse of discretion, but others you can.
So if we had a scenario where the court heard a factual basis for the plea and it was egregious, and the judge said, Mr. Defendant, I also see that you're wearing a Mickey Mouse t-shirt today, and then imposes these sentences, can we say that that is an abuse of discretion? You have to send the whole thing back, or can we say the comment about the Mickey Mouse t-shirt was improper, should not have been considered, but it really had no bearing on the sentence that was imposed?
I think you can absolutely say an arbitrary comment about Mickey Mouse is harmless in light of the facts of the case. I think you could also do it easier in this case if the judge had said, not only did I hear the factual basis, but I also relied on this, and I'm relying on both, because I think that would be, well, if you take the one out, you're still fine. But I think that's essentially the analysis for harmless error that should be applied here. If there are no further questions, I would respectfully request that you affirm the district court in this case, with the exception of the post-release versus parole. The post-release period needs to be vacated.
So you are conceding that, as counsel indicated?
Yes.
Very well. Any further questions? Thank you, counsel.
Thank you.
May it please the court. I just would like to pick up on a few things regarding the discussion of harmless error. Counsel indicated that if it was an error of law that was made, that would be abuse of discretion, but the same result would apply anyways. I don't think that that's necessarily harmless, as much as it would be right for the wrong reason, which the state could then raise in opposition to the abuse of discretion argument. But to my knowledge, and again, I tried to look, but I could not get internet, but I'm unaware of any case in which an abuse of discretion is subject to a harmless error analysis.
Let me
In
focus.
sentencing.
In sentencing.
In sentencing, because obviously in the guilt
Yes.
part of trials,
Right.
we say that errors arise out of abuses of discretion.
Right.
We conduct harmlessness.
Yes, correct.
I wonder if we're not focused kind of on the wrong thing. We've kind of been bouncing between, was there judicial misconduct, if you will, by looking outside the record in processing things. But you've raised the issue that there was an abuse of discretion by going consecutive rather than concurrent.
Based on an error of fact.
Well,
Yeah.
but so that's how we're in abuse of discretion land, and and because we all know there's discretion whether to go concurrent or consecutive. And so it seems to me that maybe that does tie back to whether we can even attribute the judge's decision to looking at the confession that he listened to versus the facts that were stated by the state when the plea was entered, and the other things that are in the record that would clearly lead you to the same conclusion. I mean, that's where. But it seems like you focused us on the act of discretion here.
I mean, I think I just simply focused on what the district court said it was basing its decision on. I mean, it stated that it was making this decision because of what he heard at the preliminary hearing.
Well,
I don't know if
It
there's...
said he's basing the decision because this was a cold-hearted killing that showed no mercy.
Right.
Now, the question is, what's the factual basis for that conclusion? And I think there's more in the record and more than what he just said than just tying it to that confession. I don't think it's quite as clean as you're making it sound.
I mean, and again, and perhaps not, but I would respectfully disagree with that, because I mean, right before he mentioned the coldness and the no mercy, he stated, I heard your statement that you gave the police at the preliminary hearing. I think that, and then directly, it is clear to the court that the final moments of this young lady's life were very cold. He showed no mercy. So regardless, this
and then he says, as a consequence, and I think that as a consequence refers to the sentence before that, which is the nature of the killing.
But if that sentence was, but if the nature of the killing was based on the statements at the co-defendant's preliminary hearing,
It
I
doesn't
think,
say that. I mean, he doesn't say that based on what I heard at the preliminary hearing, I'm doing this. He's saying, he's just acknowledging that he heard it. Then he's saying, it's clear to the court that the final moments of the young woman's life were very cold and you showed no mercy. And then as a consequence of that, I'm showing you no mercy. So anyway, I'm not trying to dispute the idea that that sentence shouldn't be in all these other sentences, but I'm not sure you get to tag it quite as heavily as being a cause and effect. Is all I'm pondering here.
correct. I see that I'm out of time yet.
Conclude by telling us what you want us to do.
I would like this court to reverse the district court and remand for resentencing, and also to cut off the district court's jurisdiction to award any restitution, and also to correct Mr. Johnson's sentence to include parole instead of lifetime post-release.
Do we have any further questions?
And not allow restitution.
And not allow restitution, yes.
All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.